Good evening, doctors. Thank you very much for making your attendance this evening and joining us for the second of the CPD events that we are doing in conjunction with the Ophthalmology Management Group. I know that a number of you in the room already have heard me speak, so I'm not going to take up too much of your time, other than to say that Genoa Underwriting Managers is a liability-focused underwriting management agency. What that means is that we focus on professional indemnity insurance for professionals like yourselves. We don't insure your cat, your dog, your mother-in-law, and instead, as I said, we are entirely focused on professional indemnity insurance, and we would be regarded as experts in this field and have been doing it for many, many years. I have the pleasure this evening in introducing Dr. Brad Byra, who will be addressing us on informed consent, disclosure, and records. I've personally heard Dr. Byra speak many times, and I'm sure that you will all find his address to us this evening to be highly informative. Before I hand over to Brad, I would also like to thank Dr. Serpentine for the opportunity to be able to offer the CPD to the OMG members. And I'm now going to hand over to you, Dr. Serpentine, to just welcome everyone here this evening.
Thank you very much, and thank you very much for Brad as well for his role in this evening. I just want to welcome all the OMG members and the awesome members to the meeting this evening. We hope you enjoy it. We hope you find it informative, and we hope that you're keeping safe in these very troubled times. I think we're all learning new things every day and learning to deal with adversity in a way that we weren't used to before, and it wasn't required. So we wish everybody good luck and to keep safe and you know, to just weather the storm. I'm sure it'll start going better at some stage and things will start returning to some form of normality. Thank you very much to the folks from Genoa for making this available to our members as well, so that we can all learn something new on this front. And thank you very much for Brad also for the presentation. So from our side, thank you very much and welcome this evening.
Thanks, Johan, and thanks, Michael, and hello to all of you. I know that by now, and I say this with the deepest respect to all of us, everyone is probably to a large extent fatigued with all of the online work that we're doing, and desperate to return to large degrees of what we used to call normal, which was go to work every day, go to our rooms every day, and do things in the way that we were familiar. Familiar is becoming an increasingly unfamiliar space, and I just wanted to take a moment to reflect on where we are in terms of COVID and in terms of our healthcare situation as we go into informed consent, disclosure, and record keeping. Because the question that we ask ourselves, and certainly being involved on some of the reporting on numbers, both here and in other areas, how much do we share without sharing panic? And how much information is good information, and at what point does information become bad information? And I'm going to use that as the segue into the talk and just share with you what was, from that particular COVID perspective, sobering for me. My birthday, which was 2 months ago, there was 105 deaths. A month ago on the same day, there were 998 deaths. On the same day today, there's 3,600 deaths. And so we're starting to see that significant shift that we've seen in other parts of the world. And I say that as a segue because it's important during this time that we manage our stress well. And it's not the topic of today's talk, but it certainly was something as I woke up this morning, an issue that I'm mindful of. So as we go forward, we're going to start off talking about ethical, social, and legal responsibilities, because that really is what informed consent, record keeping, and disclosure is about. But to set the context, as we have in the past, and for any of you who want to, there is a chat function where if you've got a question, just put it onto the chat function. I'll keep checking that function as we go through the next 50 minutes or so. And so if you've got questions, ask them. If you're thinking about the question, chances are so are one or two other people, and I will respond to that where possible in real time and where not at the end of the presentation. So kicking off this particular subject, the subject is, can we provide full and open disclosure to patients? And full and open disclosure to patients has three components to it. The first component is what we share with the patients in terms of getting them to understand what the process, procedure, condition, implications, complications, and costs could look like. The second is, who might we or might we not share that information with? And the third is, how do we record not only the dialogue with that patient, but also our diagnostic opinion, and of our diagnostic opinion, our prognosis and our treatment and the outcomes of that treatment. And so that falls into this context of full and open disclosure. And then that falls into two areas of risk for us. And it's an ethical risk for us, a social risk for us, and a legal risk for us. And the first is the error by commission. It's what we do and the information that we share. Now, sometimes the activity that we do or the procedure that we do is not as robust or as well considered or as clinically relevant or appropriate as it could be. But the other is the information that we share might be the right information heard in the wrong way, or spoken in the wrong way, or the wrong information given at the wrong time. So that would fall into your error of commission within the context of informed consent and disclosure. The second is your error by omission. And your error by omission specifically here is the failure to take the right action or leave the task undone. And in informed consent, that could well be that you decided not to get the consent because there was pressure, or because you thought that the patient might refuse, or because the dialogue was difficult. But it also includes gaps in information and communication, things that you might have left out either because you didn't think they were relevant, or because there wasn't time, or because you elected not to share it or disclose it. And the reason I start with this slide and this part of this discussion is because I'd like you to think now in terms of your practice on a daily basis. What risk are you at in terms of either work that you do? And I know that we like to believe that we're not at risk in terms of the information that we share and the activities that we do, but equally, what are you at risk of because you leave it out? Now, I don't have an answer to that, and I don't have a checklist for you at this point, but I'd like you to think about it as we go through the requirements in terms of the National Health Act and in terms of the Health Professions Council ethical guidelines, also in terms of judgments. So what I've included in today's presentation is, in addition to the pure theory of this, I also wanted to share with you some of the judgments that have been handed down by the courts from as far back as 97 years ago. The first case that I'm going to share with you is a case from 1923, right up to current days. So that's the purpose and the flow as we go through today. Again, as I said, if there's any questions, please feel free to ask them. So there was a phrase that came up recently, and in working with some of my colleagues through some of the universities and through the European Union, the phrase of meaningful consent came up. And to have a consent that's meaningful, generally what needs to happen is four things. You need to say what information, that's personal information, is being collected. Now, in the case of patient information, there's a whole range of that, and we're going to go through that. The second thing is, with whom will it be shared? Third is, why is it being collected? And the fourth is, what are the risks of harm or other consequences that a person who's sharing this information may be exposed to? In doing that, in doing those four things, collecting personal information, potentially sharing that information, why are we sharing it and why are we collecting it, and what the risks of harm would be, we then have to provide the other person, in this case the healthcare user or our patient, with a clear choice of what they can agree to or not agree to, and including how we plan to use or disclose this information. Now, as we go through, if I don't say it later, under the Health Professions Council, under the booklet 4, which is informed consent, there is a section around ICD codes, because one of the things that you have to be able to share in consent, which is the expression of will, as you can see, is you have to share the reality that you're going to be sharing not only patient information with other healthcare providers potentially, but you're also going to be potentially sharing that information with medical funders. And the ICD coding is a important piece to that. Also, under meaningful consent, you need to recognize one or two things. And one of them is that the individual can withdraw their consent. So they can withdraw their consent for you to retain the records. They can withdraw their consent for you to share their information. And you need to, in your consent forms, make provision for the withdrawal of consent in addition to the provision of them giving you permission to do things. Nowadays, and I say nowadays because the POPI Act, the Protection of Personal Information Act, which was promulgated in 2013, its final provisions came into effect as of the 1st of July. So now how you protect that information, how you store that information, what purposes you would store that information for, are not only protected under the National Health Act and guided under the Health Professions Council with our registrations, but it also now sits under acts broader than that, not only the Constitution and the Bill of Rights, but also POPI. So I'm sharing that with you so that you understand that there are provisions broader, not that you didn't know that before, but it's good to share that information with you. So informed consent is about getting permission before conducting a healthcare intervention and before disclosing personal information and before creating an obligation. One of the biggest fights that we've seen over the years of looking at medico-legal dispute is around the person saying, I didn't know it was going to cost that much. And I didn't know that my provider, my healthcare provider, was going to bill me. And I didn't know that my funder wasn't going to pay. So that's the creation of an obligation. So when you start your work with a patient, please understand that the creation of the obligation also includes the financial obligations that they have to you, that you expect them to pay and when you expect them to pay. And also think about if something goes wrong, if there's a complication, do you still expect them to pay? Do you still expect them to pay for the, let's call it the procedural redo or the adverse outcomes and the care that's needed? So bear that in mind, because that extends also to the therapy that you're giving. If there's clinical research, you've got to get permissions, multiple permissions from that research participant. And all of this falls under the collection, which is in the guidelines, both in our case in the medical guidelines. And we'll talk about it, but it's specifically guidelines 1 and 2 around how you behave as a practitioner, but also booklet 4, which is on informed consent, and booklets 5 and booklets 9, which are maintaining confidentiality and record keeping. So the National Health Act, our National Health Act, makes it an offense to provide a health service to a patient, or what they call a user, without their informed consent. So I use the story of Dr. Mark, one of your colleagues, again with his permission. What I've highlighted there is one of the lessons learned is that informed consent is the entire doctor-patient experience. It's not only the document that's signed in the waiting room or the document that's signed pre-procedure, because you would have the general consent that you would have with the patient, which incidentally, if you're seeing a patient and you haven't seen them for a period of time and you can select that time for probably 3 to 6 months, you need to get them to re-sign your practice consent because they might have forgotten it or it might have changed. But also all procedural consent needs to be done. So the story with the colleague very much was the expression of what we learn, that it's the whole journey. It's from when the patient comes in to when the patient leaves, with the medicines potentially that they need to take and your expectations of follow-ups with them, so that you can know whether the care that you've given has given a good outcome or if there's a bad outcome. Sometimes the lack of an understanding of follow-up or the patient's obligations in follow-up means that, and I'll give you an example of this, but what it means is that the patient's expectation of their outcome and your expectations of the outcome are not clearly aligned, which would be a story of a failed consent. So I had an individual call me the other day and he said, I've got the world's worst surgery. I woke up and he was going to be repairing my inguinal hernia, and I expected there to be mesh. And when I woke up, he said that I was told that there was no mesh because it wasn't a hernia. There was an infection, which is now cleaned out, and I'm now really mad. I said, well, have you spoken to the practitioner? He said, no, I haven't spoken to him yet. I said, well, did you understand when you went in that you might not wake up with mesh and sutures, that you might just have a laparoscopic hole? Yes, but I didn't understand what that meant, was his response. So the reason that I bring this up is because your consent needs to be clear enough that the patient understands not only what you will be doing, but what you may do differently from their understanding. And that's where you find difficulties start to materialize. So there's a challenge with consent, and I particularly like this because I find myself often saying, well, do you want to go the high road, the medium road, or the low road? These are the benefits of each road. These are the harms of each road. These are the risks of each road. Now, which route would you like to go? And it almost creates the position where nothing can be done because it's too confusing or too confounding. So the defining of consent is part of your natural duties and moral obligations. It's also a legal duty that you have as a healthcare practitioner. The obligations that you have to provide informed consent is an ongoing process. And you can read that in section 5.3.4 of booklet 1 of the Health Professions Council. What I would suggest that you do is you have a read, and you can download the entire book of ethical guidelines. And those of you that would like it, I'm very happy through Genoa and through yourselves to share it with you. It's a comfortable 334 pages of reading, of which all of the books are considered there. But what you need to be aware of in terms of informed consent is that there are 4 considerations. You need to give details of the potential condition and what the other alternative conditions might be. You also need to give details of the type of investigations and the treatment options. You also need to talk about the potential risks and complications of each of those conditions, and sometimes even of the adjacent situations. And those adjacent situations may be non-aligned comorbidities that may or may not affect the decision that the patient makes. You also, and most importantly, and I've added this in recently, is you need to give information around costs, because people get surprised, not so much when they have an outcome that's poor, but when they get a bill that's attached to that outcome. And that's usually what triggers a complaint. So informed consent by pure definition is to tell somebody something specific and have them agree to allow you to do something based on the facts that they've been shared. And it's based off the doctrine, and you can read it, that says to a willing person, no injury is done, or to a willing person, injury is not done. So in order to do that, there's a couple of criteria that you can see there. But by pure definition, a patient's knowing choice about their medical treatment or procedure is their informed consent. And it requires the information to be given in a manner that the patient can understand. So there's a couple of pieces there that you need to understand. What you're doing needs to be recognized by law, and it mustn't be against good morals. You can't be doing something that's unlawful and have them consent to it. It must be given by a person who's capable of giving consent. And we're going to go through the different levels of consent that apply to a child under the age of 9, under the age of 12, and under the age of 18. It also applies to persons who may or may not have the capacity to give consent, either because there's an emergency and they're not conscious, or because they've got diminished mental capacity. We're going to talk about that, but it relates to both the intention and understanding of the person and to what they can and can't do. It also needs to be free and voluntary. You can't force consent. You can't say there is a condition to this consent that you have to do this, because the minute you do that, you go back to number one that says it's against good morals. There has to be a knowledge and awareness of the nature and extent of the risk, and your patient needs to, or their family needs to, or the third party guardian or curator or a person looking after the child, if they're a minor, needs to appreciate and understand not only that they've got the knowledge of what is going to be done and what could go wrong or what the extent of that could be, but they need to understand the implications of that. So you could have an adverse outcome that could lead to temporary damage or permanent impairment, which has consequences. So they need to understand and agree to allow you to do something that could lead to harm. In other words, they agree to assume the risk. The consent needs to be broad, and it needs to include everything from the examination through to the treatment, through to the consequences if they don't accept treatment, through to the consequences of the costs that they are entering into the contract to. It must be clear and unequivocal, and we're going to talk about that a bit later. In other words, it must be language and literacy independent. It can't be such that a person says, well, I didn't understand what you were saying. It needs to link directly to the conduct that you're doing. You can't ask a person for consent for one thing and then do another thing. And so what you do needs to be specific to the consent that's given. So one of the challenges that we often face is that people say, well, you gave me consent to do whatever I needed to do. And the person says, no, I gave you consent to do this procedure. You did a separate procedure. And so if there's a likelihood that you may need to do a separate procedure during the same sedation, as an example, you need to say to the patient beforehand, there are 2 or 3 different outcomes that may happen when we start to go and begin this procedure. I need your permission not only to do the principal intervention, but if there's another intervention, I need your permission to do that as well. So it's a lot more complicated. So why do we do informed consent? And we do it in terms of the rights that the person has that are enshrined. And some of those rights go back to, let's say they go back ad infinitum, but practically they go back to the late 1940s and very early 1950s, to the Universal Declaration of Fundamental Human Rights. And basically our constitution, the South African Constitution under Section 12, says that everyone has the right to be free from all forms of violence, from either a public or a private source. Now that's important in our context, because later on you'll see that if you do a procedure without a person giving consent, that may be regarded as assault on that person, and so it may infringe their rights under Section 12(1)(c) of the Bill of Rights. Under Section 12(2), a patient or any of us also has the rights to bodily and psychological integrity, which includes the rights to their security in and control of their body. And the giving of consent is the execution of those rights of control of their body by giving you permission. So if you do an action without giving that patient the rights to understand and having them give you the rights for permission, you're actually in contravention of their constitutional rights and their fundamental human rights. Now, those are our basic inalienable rights. And off the basis of those inalienable rights, you then have acts like the National Health Act. So what I'm giving you here, and I say this with the deepest respect and empathy, because we go through the legal aspects of what we need to be doing as a clinician or as a practitioner. And sometimes you look at all of this and you think, this can be absolutely overwhelming. How am I going to run my practice when I've got all of this pressure to run these consents? And there's feedback that we often get that says, well, I need to be a legal practitioner and a contract specialist in order just to do the care that I want to do. So I'm sharing this with you. If those of you have got questions, you're welcome to them. These are the key parts of the Act. So under the National Health Act, Section 6, it says that the user and they define any person who consumes healthcare, any patient, and any carer of that patient or guardian of that patient or parent of that patient to be a user. And that user needs to have full knowledge. Now, every healthcare provider must inform the user of their health status, except where providing that information would not be in the best interest of the user. Equally, the user has the right to refuse health services. Now, that becomes delicate for us in certain areas because we want to give that user care. We want to help them, but they've got the rights to say no. And we then need to explain the implications and the risks to them in a manner that they can make that decision, understanding the implications and risks. So in terms of us giving information for consent, we must give them, the user, the information in the language that they understand and consistent with their level of literacy. Now that sometimes becomes a challenge, because I remember when we started, my first diagnostics lecturer said, well, now that you're here and you're busy doing this work, we are teaching you a whole new language. And you've got to learn that language so that you can get past your certification and your qualifications. But for the rest of your life, you're going to be translating that language away from what you know into the language that your patient needs to hear. And that's what section 6.2 says. You can't go in and say, well, we've got this diagnostic opinion and it's based on the metabolic outputs, based on the secondary infections and the pathogenesis. You've got to be able to say, because of this particular infection that's affecting you in this way and changing the way your body is responding, you are likely to get the following things happen. Now, it's a little bit easier nowadays because with the internet and with the majority of information we've got, you can use graphics, you can use videos, you can use animation in order to explain things. But that giving over of information that requires both knowledge and appreciation is linked to your ability to share the information with them in a way that they can hear. Now, you may, those of you that like to read outside of the discipline, Edward de Bono wrote a significant series of books on problem solving and communication. And one of his books he wrote was a book called Simplicity. And he said, in order to make it simple, you have to really, really know it. So the challenge that we have is, how do we make the information that we want to share with patients easy enough that they can gain the knowledge, the appreciation of it, and recognize what is valuable and important to them. So it's not an easy task. The National Health Act then goes forward to say that the consent of the user must be obtained, except in exceptional circumstances. So one of the circumstances where you don't have to obtain it is where the patient cannot give it. So if the user is unable to give it, that consent has to be given by a person mandated in writing. So I would have to say in writing that so-and-so would be giving the consent on my behalf. As a minor, the parent has to give it in writing, or the court has to give it in writing. So for children, under the Children's Act, you know, and if you don't know, that the ultimate guardian or custodian of the child's rights is the court. So if I can't give my consent, the consent can be given in order by my spouse or life partner, by my parent, my grandparent, an adult child, or a sibling, in that order. So a sibling can't give consent if there's a spouse or partner, or if the parent is compos mentis and able to do so. So bear in mind that the individual may not be able to give consent, but somebody may be able to give consent on their behalf, failing which they can get authorization from the courts. And then it gets into a slightly gray area of consent, because one of the things is, if a failure to treat the patient will result in a serious risk to public health, there's an obligation to treat. Now that's a gray area, and I'm not sure if it fully applies in your area, but we're seeing that at the moment with COVID. Now, the question would be, at what point is there a serious enough risk to public health to intervene without the permission of a patient? And it's a difficult question. So there's a question that's come through: how do we manage informed consent when the patient is not capable of agreeing consent and the spouse is not willing to sign consent, and the patient is at high risk? Well, that's a difficult one. If the patient cannot give consent and the spouse refuses to give consent, your next route, if you believe that that patient is in imminent danger, is to get an urgent order from the court. Now, in order to get that urgent order from the court, you have to demonstrate the serious risk, and that's what you see there in 7.1e, is that any delay in care may result in death or irreversible damage to that person's health. So if you, as the practitioner and the institution where that individual is, have consensus that would result in irreversible damage or death, and you cannot get consent, you can then petition the court. But prior to that, the first question the court will ask is, have you taken, as the health provider, all reasonable steps to get the user's informed consent? If you haven't taken all reasonable steps, it's going to be difficult. And then the very fair question is, well, who bears the cost of getting that consent? Well, if you believe that there's imminent danger to that patient, and you can justify that you've provided a life-saving endeavor, your second biggest question is, could the patient pay for this? And would the patient's funder have paid for this? Generally speaking, you would have to then have a very delicate balance that you walk in trying to recover that money. I don't know the immediate answer to that. I don't think you'll be able to justifiably recover that money if the patient says they couldn't pay. And so that's generally where you would find that the institution petitions, and you would then walk a tight line to say, well, how do you recover? I don't believe you can recover the costs on a personal basis, but you would have to look at that against the morality of the intervention that you've done. The third piece of that, which is section 7.3, the National Health Act defines consent as the provision of a specific health service given by a person with legal capacity to do so, and who's been informed and contemplated. So it's a very delicate line that you walk, and generally speaking, in your practices, I think it'll be highly unusual for you to be seeking consent from a court of law. I think in the general case, you will be seeking consent from the individual, and depending on how you work with your pediatric community, with your children community, you may or may not be seeing this where you would need written consent from the parent if the child is not precocious enough. And we're going to go through that in a little while. So taking it forward a step, the first case in South African law on consent was Stoffberg versus Elliott, which was in 1923, where the statement was that any bodily interference that affects a person that they have not consented to is wrong. That then moved on to a case, what was called the locus classicus case. It's the case that we most often refer to, and that was Castile versus de Greef in 1994, where it was stated that the doctor's duty to disclose a material risk must be seen in a contractual setting. And so any consequences of not disclosing that risk is the failure of the doctor to do what they are contractually obligated to do. And if they then act without the patient's consent, it is considered not to be negligence, rather to be assault. And so you will see there that it says in reference to a case of Rogers versus Whittaker, that the doctor has the duty to warn the patient, not warn the patient, warn the patient of a material risk inherent in a proposed treatment. This duty is subject to therapeutic privilege, but if you know that there's a consequence that may happen, you do need to speak about that. So if you fail, and you'll see on the right-hand side that if you fail to disclose the risk, you are liable for the action of assault. Whereas if you do disclose it, you may frighten the patient into having or not having the operation. So you've got to you walk a tight line, and even in the judiciary, there's a mixed opinion as to how much information is good versus bad. So to what degree of risk should be disclosed to a patient? Well, the Health Professions Council, 2 years ago, I was having a conversation like this, and at that stage, if there was a 2% risk that there was the risk to a patient, you need to disclose it. That's now become if there's a 1% risk. So if there is any risk, any reasonable risk of a complication, you need to share it. So there's a comment made that says the patient declines treatment for a condition posing an imminent risk to vision, adequate to recording in clinical notes, or need to have the patient sign written record of their decision. Both. You would need to say in your clinical notes that I've informed this patient of what I believe their risks to be, and that the risk of a non-engagement would be a loss to vision versus the complications of the engagement, which would be A, B, or C. Then you would need a written record where the patient says, I've elected not to follow your treatment, and you can record that in any fashion of way, and then that becomes part of your clinical notes, because the patient might forget that. They may come back and say, hey, I went to see Dr. Brad, and Dr. Brad said to me, I didn't really need this, and I may or may not have lost my sight, and it was a low risk. Well, now I've lost my sight, and I'm holding Brad responsible. You need to be able to, sadly, be able to prove in the absence of your memory, unequivocally, that you had express consent, and express means written. So I hope I'm making sense as we go forward and not terrifying you out of practice. And you'll see the final note at the bottom there is McDonald versus Roe. No informed consent, or the absence of informed consent, is a violation of the plaintiff's right to bodily integrity. Equally, if you don't keep your records, you are not consistent with your obligations, with your registration and practice obligations in terms of booklets 5 and 9 of the ethical guidelines. So I hope this is helping. I've made a note there in terms of the Mental Health Care Act, simply because sometimes we're asked to give care where the consent to care may be difficult. And under the Mental Health Care Act, Chapter 9, sometimes there is a difficulty on consent to care. So the healthcare provider or a health establishment may provide care only if the user has consented, or if authorized by a court order or by the review board of that health establishment, or where due to illness, the delay in providing care may result in death or irreversible harm, or results in the user creating harm to themselves or to others. So what you need to bear in mind if you're providing healthcare to or interventions to persons who have limited capacity, that specifically if the user is lucid, they can give you consent. If they are not lucid, you need a court order or a review board permission, and you would be guided by them if the delay in providing care would result in irreversible harm. Now, I don't know how often you'll find that, but generally there are well-written protocol in the institutions for that you can follow without you having to go too far down the slippery slope. So there are general ethical rules in booklet 2 that speak to the main responsibilities of the health practitioner. The first thing that I would say there is the ethical rule of respect, respect, respect comes into play. And so you as a practitioner, or me as a practitioner, or any one of us needs to follow a very simple set of guidelines. The first is we need to respect patient confidentiality, privacy, and then a big circle would go around choices and dignity. So we can't force a patient to do what we want them to do. We also have to bear in mind that dignity for them is a major issue. Now, I use the issue of loss of sight in this because it's very close to my heart, because my grandfather had bilateral retinal detachment and ended up losing sight in both eyes fairly young. I still wear the Braille watch that he had, which is now 50+ years old. And the difficulty that you have there is, what choices will this patient have, and do they understand the impact of your intervention or withholding of intervention to both their choices and their future dignity. We need to provide them adequate information. And the word there is adequate. You need to decide based on your practice, based on the intervention that you're giving, how much information is adequate for you being able to understand what potentially is wrong with that patient, what treatment you need to give them and what the alternatives are, what the costs are. We've spoken about this, and what the alternatives are. That's under section 27A, subsections B and D. And G specifically says, except in an emergency, you need to get consent at all times. Now, there are 4 golden rules. These golden rules are set out already, if you think about it, 30 years ago. You need to obtain consent from the person who is legally competent to give consent. You need to obtain informed consent. It needs to be clear and unequivocal, and it needs to be comprehensive. So my question to you, if we go back to slide 1, and slide 1 was the slide that spoke about the errors by omission and the errors by commission. If you went back and you had a look at your informed consent forms and your procedural consent forms, do they tick these 4 golden rules? Is it informed? Is what you're asking clear and unequivocal? And is it comprehensive? And if it's not, possibly there needs to be some updating and amendment to your forms. So the question that's come up now is, patient asks or may not even ask, but wants to record with a cell phone the discussions. Can you refuse the recording of the discussion? Now, that's an interesting debate. And under the, there's an act called the RICA Act, which relates to the recording of information and communications. The patient doesn't need your permission to record the consultation. However, you need their permission to record the consultation. So my informed consent form, and if any of you want it, I'm very happy to share it with you, says, I recognize that under RICA, you have the rights to record. But I'm asking you to record with my consent so that I'm aware that you're recording. So by putting that on the table up front, you clear the air. So you're saying to the patient, absolutely, you can record. And in our technology-rich world that we live in now, one of the things that you should be considering is that you record all your consultations. And you say to your patient, all our consultations are recorded and digitally archived. Then you can make your notes, and we're going to talk in the next section now about the kind of notes that you need to take. And then then what you can do is you can take your handwritten contemporaneous notes, but they're there to supplement the voice recordings. Because now, I don't know about you, but I work on a PC and I work on Microsoft. I have 1 terabyte of free data. And so I can store all my patient records, all my recordings, all my imaging for free on the cloud. So you should be considering right now that your health records are both written and recorded. So a health record by definition under booklet 9 is any relevant record made by a healthcare practitioner, you, at the time of or subsequent to the consultation and or the examination or the application of health management. The only challenge that you have is you don't want to make the record too far away from the date of the consultation, because you might be challenged to say, excuse me, did you remember? Have you recorded things properly? So under the guidelines and in terms of the National Health Act, records need to match a couple of requirements. The first is, if they're going to be handwritten, they need to be contemporaneous. And we'll go through what that means. They also a health record is previous practitioner's notes, also any referral letters to or from healthcare practitioners, all laboratory reports, all histology sections, all cytology, all printouts, all x-ray films and reports, all traces are considered to be part of the records. Any audiovisual records, any photographs, videos, tape recordings, and now digital recordings, any clinical research forms, any forms completed like your insurance forms or medical aid forms, any disability assessments and death certificates are all considered to be medical records and all need to be treated accordingly. So you can see there's a large group of definitions that forms a record. So in terms of Rule 15, anyone who signs official documents, including prescriptions, certificates, patient records, needs to do so in pen, not in pencil, in ballpoint ink, and they need to put their initials and surname in block letters plus their signature. And that includes any amendments that you do. So documents, why do we need to keep our documents? So let's just move away from section 3.1.5, which is as direct evidence in litigation or for occupational compensation purposes. But you need to keep them for diagnosis and ongoing clinical management of that patient, because we just can't remember it. If I asked you the question, I said, what did you have for dinner 3 weeks ago on Tuesday? Or what color shirt did you wear 8 weeks ago on Wednesday? If you don't know the answer to those questions because you don't have that kind of didactic memory, you also can't remember what you did with which patient on which day and when. So furthering the diagnosis and ongoing management is important. Conducting clinical audits. Now, I don't know how many of you conduct clinical audits, but clinical audits is a very important part of understanding the background of who you're treating, what their outcomes are, the effectiveness and efficacy of what you're doing. They also promote teaching and research, both within your practice and other side. They're used for administration. They're used for research data. They're used for historical purposes. They also promote good clinical and laboratory practices. I don't know how many of you do case reviews, and if not, why not? And in many cases, they serve as the basis for accreditation. So your clinical records, which you keep, you need to be keeping in terms of booklet 5 and in terms of booklet 9 of the ethical guidelines, specifically for diagnosis and ongoing management, specifically for administrative purposes, but also in the worst case scenario, because of the issues that the risks of litigation pose. And I'm noting that we're silent on the questions now. I've either scared you or answered your questions thoroughly. So the question is, which organization or entity would you recommend that we can use to review our current practice informed consent forms from a clinical, surgical, financial perspective? We will share with you maybe a list. There isn't one organization who specifically writes or can review informed consent forms. There's a couple of really good medical legal practitioners and medical legal firms that can do that. But I think maybe that's a conversation to be had through the practice group. So I'm not going to answer that now. And part of the reason I'm not going to answer that is because if I mention one person and you go and see that one person and they don't do a great job, I hold what's called vicarious liability. And then you come back and you say, well, Brad told me to use MJ and Johan did a bad job, and because Johan's done a bad job, I feel aggrieved. So I'm sorry that I can't answer that as directly as you might like. What is the youngest legal age that a patient can give consent themselves? So there's a couple of journeys with that. In our world, it depends on how precocious or how aware that patient is. So a patient younger than 12 needs to have written consent from their legal guardian or parent. A person over the age of 12 can give consent with the assistance of their parent or guardian, which also needs to be in writing. Person over the age of 18 can give consent unless they are mentally impaired. So there's a range, but the youngest would be 12, who fully understood the implications of what you were doing, and that still needs to be recorded and had in writing. That includes the consent of the parent. So when we go through now your records should at the very least hold the following information. Some of the information that your record should hold is that it should hold the identifying particulars of the patient. So who is that patient? What is their age, their race, their gender, their geography? It should include their psychosocial history, and it's recommended that you include their idiosyncrasies. What were they like? Were they emotional? Were they steady? Were they distressed? What was their affect at the time? Because sometimes that makes a material role in the decisions that you make, or it shows that there was a degree of stress or absence of stress later on. You should be recording the time, date, and place of every consultation. If you're using an electronic medical record, then this forms generally part of that record. I use an electronic record. If you're using your written notes, you should be saying these consultations occurred at the practice at X, Y, or Z time. You should be giving an assessment of the patient's condition, both subjective, what they've told you, and objective of what you've seen, what your proposed management is. The medication and dosage prescribed. Now, I do and recently reviewed a talk on medication errors, and the 5 rights of the patient as it relates to medication and dosage is important, because not only should you be recording the medication and dosage, but also the manner in which you've instructed the patient and the importance of their compliance with that medication and dosage, and what the potential side effects should be. If you're referring, that needs to be recorded into the records. The patient's reaction to the treatment and medication should be recorded. And there I ask the question, by those errors of omission or commission, do you follow up the next day or post-procedure, not only post-discharge, but also 24 or 48 hours later, to record the reaction of that patient to the treatment or their medication? And then you can see the test results need to be recorded, as does investigative results, information if the patient was booked off, and written proof of informed consent. Again, if you are, you'll see on the left-hand side, if you are making changes, you need to make those changes in a permanent manner, given the reason of why your amendments were made. And they need to be recorded, they need to be clear, they need to be concise and unequivocal. They can't be subject to interpretation. So as we go forward, the questions aged and of age comes up here. Health records need to be stored for no less than 6 years after the date that they become dormant. So now the question is, how are you recording them? Either digitally, where you scan them in, or in a box off-site, like on a Metrofile type of use. So they need to be stored. If they're electronic, they need to have passwords, at least a 2-phase form of identification and access. Minors, their records need to be kept for longer. For a minor, the age is 18 plus 3 years, because after their 18th birthday, they can seek redress from you for the year after their majority. And then there's a 3-year prescription that allows to that. That's the same for obstetric records. So if you're treating children and you're treating peds and young kids, know that you've got a 21-year window. So my last young child that I treated in 2000, next year is the last year that my practice needed to keep those records. For a person who's mentally incompetent, those records are there for a patient's lifetime. If you're doing any sort of work for an occupational health and safety related injury, where there was a shard of hot metal that went in, or there was any ocular injuries, you need to keep those for a period of 20 years post-treatment. So your retention of records is for an extended period of time. Bear in mind that a person over the age of 12 may have access to their records on request in terms of the Children's Act. Person under the age of 16 can make application through their parent or guardian for access to that information, and that's provided for the Access of Information Act. Information about termination of pregnancy, while it doesn't apply to you, relates to any patient over the age of 9. and that's under the Choice of Information on the Termination of Pregnancies Act. And what's important here is that no practitioner can make information available to any third party without the written authorization of the patient or a court order, or where non-disclosure would lead to a serious threat on public health. We're seeing the third one in terms of the declarations of COVID status. But for anyone under the age of majority, anyone under the age of 18, you have to get written authorization from the patient and the parent if the patient is younger, plus and or a court order as needs be. So as we move to the last slides, summaries are that your records must be complete but concise. You don't have to take narrative that is multiple pages. Your records should be consistent amongst patients. You can keep standardized formats that can be used in order to manage it. Any alterations you make, as you saw earlier, should be signed in full and dated. Copies of records should only be released with proper authorization. Billing records are separate from patient records, but both can be requested. You must also make sure that you keep diagrams, laboratory results, photograph charts, and these should be labeled because they can easily go wayward. And we've seen often that there's been cases of complaints as a consequence of that. So the question is, does every patient that consults at a practice have to sign that they know there's a risk of contracting COVID, despite the fact that we're following guidelines? And as notifiable disease, whose responsibility is it to report COVID? So we're slightly off-piste on this, but let's just talk about that. So anyone who comes into your practice, you should be having a COVID declaration for everyone who comes into your practice. You should be recording everyone who comes in. You should be doing screening on everyone who comes in, a temperature check, and have a record of who came in for tracking and tracing. So each patient who comes in needs to recognize that because they've come into your practice, they had a risk of a potential exposure, not only through coming to you, but through the journey of coming to you. So you would be saying to them, we follow all the IPCs, the infection prevention and control. We are sanitizing, we have hygiene, we are managing social distance, we are using PPE, and we recognize that there is always a risk. As the notifiable disease, who is the duty to report the COVID positive person? When a person goes for testing, they will go for testing. The outcomes of that testing will go through if they're positive to the NICD. They are responsible then for initiating the contact tracing. If you are aware that a patient of yours is COVID positive, you should also be notifying the NICD that you're aware that you have a patient who's COVID positive. You would need to then look at that in terms of contact tracing and saying, was that patient in a position where they were potentially exposing others? And if you were COVID positive, you would need to look back over the period of time and identify who you potentially exposed so that they could receive the right kind of follow-up in the appropriate way. So that, I suppose, takes us to where we are on disclosure. So you need to just make sure here with disclosure that the patients have the right to expect that information about themselves will be held in confidence. Improper disclosure happens. Corridor talk does it. Nowadays with social media and sharing on WhatsApp groups and sharing on other groups puts you at risk of inadvertently sharing information. And you need to have heightened awareness in terms of both risks for social media and risks in terms of telehealth and telemedicine, that your disclosure needs to be very discreet. And where it is discreet, you need to make sure when you are sharing information about patients in an anonymous way that they cannot be identified. If you're looking to share patient information with a broader healthcare team, patients need to be told about this and they need to give you that permission in writing to do so. In disclosure in the public interest, all such cases, you need to weigh up the possible harm. In a case like COVID that we've just spoken about, the Disaster Management Act is actually quite explicit that if there is a known infection and it has the risk of being spread, for the purposes of contact tracing, you need to be able to share that information. I think in the cases of the practices that you're running, that patient will have already included you on the contact tracing list. So it's more likely that you'll find out that the patient is COVID positive because the NICD track and trace people are calling you versus the other way around. So just to wrap up my comments on that, when you are satisfied that information should be released, you need to act promptly to disclose that relevant information while safeguarding the well-being and the interests of the patient and their and anyone else. So that's brought us to time. I hope it hasn't felt like a long evening for you, because it felt like it was a really short hour for me. The last question that's come in now is, a husband of two wives who's unable to give consent, what is the correct action if one wife is giving the consent while the other is refusing? I suppose that depends on the marital status. Generally speaking, you may find where there is a situation where there is polygamy, that the first wife is the wife who has permission to give consent within the architecture of the relationship. But I don't know the answer categorically. You may find in those cases where there's a religious leader, there may need to be mediation between those two wives, and the failure to get consent, if it is going to create imminent harm, may lead you to have to go to the courts to get that answer. At this point, MJ, I'm going to hand back to yourself and Johan, and answer any other questions that you might have.
Thank you, Brad, for a very informative talk. Doctors, at this point in the evening, we now hand back to the floor. There are quite a few of you who are speaking, or at least who are in attendance now. I think we've got about 60 or 65 people that are in the room. So if you do find that someone else is talking at the same time as you, please just obviously pull back on the question. In order to address Brad directly, you hold down space bar on your laptop or computer, and that'll demute you and it'll allow you to ask any questions. So I'll hand to the floor now to see whether anyone has got any other questions other than the ones that Brad has raised in the group chat. Also, if you aren't able to raise to speak, please just do type them in the group chat and Brad can then address your questions like that. We'll just wait a couple minutes to see whether anyone has any questions. And if not, then we will thank you for the night and we'll close off. So I hand back to the floor now.
Can I speak?
Go ahead.
Of course.
Hi. If a doctor turns out positive, and what obligation has he got to inform the patients he's seen if he was always adequately covered by PPEs?
Yeah, that's a difficult one. So let's look at where we are now in terms of the airborne contagion risk theory and the issues of what we regard as adequate or less adequate ventilation. So let's say I'm the practitioner, and maybe while I was seeing you, I was diligent and I had a mask on, but when you weren't there as a patient, I took the mask off and washed my hands, I had a bit of a sneeze or a cough, or drank my coffee. Well, that airborne infection may have lingered to the point that a vulnerable person whose immune system just wasn't as robust, or the virus that was more virulently mutated got into their space, you may have inadvertently contaminated your space. So the duty, if we go, I was introduced to the concept of ESLI, the ethical, social, and legal implications of our actions. I do think that you would have an obligation to go back at least 5 days worth of patients and notify them that whilst you did take extreme precautions and you did wear PPE and you were running your practice, you are notifying them that you have tested positive and they may or may not have been exposed. So you recommend that they follow the self-isolation and if symptomatic testing protocol. I think it would be good social practice, let alone good clinical efficacy.
Thanks, Brad. Doctors, anyone else got any last questions for Brad before we sign off and allow everyone to go and grab some dinner? Dr. Serpentine, have you got any last words, or are you all good?
No, I'm all good. I just want to wish everyone a good evening, and thank you very much for attending this evening, and thank you to Brad and yourself as well for assisting us to make this happen. Yeah, and we look forward. We'll have the next one will be on the 22nd of July. We'll have another one of these, and we hope that it will be informative as well, and that everybody will attend that. So thank you very much, everyone, for your attendance this evening.
All right, Brad, thank you very much from our side. Doctors, be safe and have a good evening, everyone, and we look forward to seeing you at the next event. Ciao.
Thanks so much.